Friends, in episode 6 on legal language, let's see some concepts in criminal law. Offence. What is an offence? Offence is an act which is wrong in the eyes of criminal law. Please note, in case of civil law, it is called tort. Indian Penal Code (IPC) defines offence as something which is made punishable under Indian Penal Code. Punishments for offences are also found in IPC, that is Indian Penal Code. These range from death penalty to imprisonment, which may be simple, rigorous or solitary, and fine. Now, in criminal law, the offence is considered to be against the state, whereas in civil case, it is the offence or if the tort is committed against some other person. So, the criminal cases always run Mr. So and so versus state of Maharashtra or state of Gujarat, etc. IPC deals with various types of offences and sentences for each. Now, there are 4 basic stages in commission of an offence. First, there is intention. Second is preparation to commit a crime. Third is attempt to commit crime. And fourth is commission of an offence. So these are the 4 stages. So there must be an intention, then there should be a preparation to commit the crime. Third is the person attempt to commit the crime, and fourth is actual offence is commissioned. There are 4 stages or 4 basic elements in any offence. These 4 basic elements are must for offence or crime to take place. One is whoever, that means a person has to be there against who commits the offence. We cannot say that a buffalo or any animal committed an offence. Second, which is called intention, which is mens rea. This is very essential element of a offence. There has to be an intention or mens rea. If there is no intention to commit a crime, then it is not considered as a crime. Third is actus reus, which is actual act. So actual act has to be committed by someone to make it is offense. And third and lastly, fourth is most important, is there should be injury. Now, if there is no injury, then offense will not stand. So whoever, that is a person, mens rea, that is intention, actus reus, that is a act, actual act of an offense, and injury, which is the effect of that act, are all essential elements of a offense. Now, what is complaint? Complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under criminal procedure code that some person, whether known or unknown, has committed an offense. So, as you know, the police can also record an offense against an unknown person when you do not know who has committed the offense. What is charge? Charge is a precise formulation of a specific accusation made against a person for an offense alleged to have been committed by him. The framing of a charge is the vital to the criminal trial. So that means a charge has to be framed before the criminal trial begins. A charge must state offense. If the law has given a specific name to that offense, it must be described by that name only. Third is the relevant section in Indian Penal Code must be mentioned in the charge. And fourth is the charge must be written in the same language of the court. There must be a separate charge for every distinct offense committed. Now please note, charge under Transfer of Property Act has a different meaning altogether, which we have already seen in TOP episodes. What is bail? Bail is setting the accused person free before he is tried. often on a condition that a sum of money would be forfeited if he does not attend the trial. In the welfare society as we are today, it is considered that bail is a rule and the jail is an exception. All offences are either bailable or non-bailable. In the bailable offences, magistrate must grant a bail. He has no choice. However, in case of non-bailable offences, court may release a person on bail only subject to conditions laid down in section 437 of the Criminal Procedure Code. Non-bailable offences are severe in nature. There is a schedule given in Criminal Procedure Code as to which are the bailable offence and which are not. While granting the bail, the court can impose some restrictions on the accused. Bail can be in the form of cash amount to be deposited in court or personal bond, which is executed by accused with one or more sureties, wherein they undertake to pay the court surety amount if the accused failed to present himself in the court. What is anticipatory bail? It is a bail before arrest. If any person has reason to believe that he may be arrested on accusation that he has committed non-bailable offence, he may apply to Sessions Court or High Court for anticipatory bail under section 438 of Criminal Procedure Code, CRPC. So court directs that if a person is arrested on that particular charge, he should be released on bail. Court can impose some conditions before granting anticipatory bail, or court can even reject the bail application. The rejection of the bail application in non-bailable offences can take place if the court feels that there is a chance that the accused may be able to influence the witnesses or abscond from the country, run away, etc. etc. Anticipatory bail can be cancelled if sufficient cause is shown later on. Even if you have got anticipatory bail and if sufficient cause is shown that he has interfered with the witnesses or trying to abscond from the country, the anticipatory bail can be cancelled. Now, what is conviction? If at the end of the trial it is proved that the person has committed the offence, he is said to be convicted. What is acquittal? If it cannot be proved that the accused has committed the offence, then he is acquitted. Now there is third term as discharge. If the court finds no ground to proceed against the accused brought before it, the court may discharge him. That means court finds that there is no sufficient ground to try this person, so let's discharge the case. Let us discharge him of all the accusations made. If there is sufficient ground, then the charges are framed and the trial begins. There is a common law maxim, nemo debet bis vixari, which says that a man cannot be brought into danger for one and the same offence more than once. This is a rule against double jeopardy referred to Article 20 in Constitution of India. So also Section 300 of Criminal Procedure Code. However, it is to be noted that Section 300 of CRPC dismissal of a complaint or discharge of an accused does not amount to acquittal for the purpose of rule against double jeopardy. That means if a person was earlier discharged from the case, but later on it is found that sufficient ground is there to try him out, then again a case can be filed and he cannot take advantage of this double jeopardy referred in Article 20 of the Constitution of India. We end here, friends, and next episode we will see some legal maxims